Mama's in the living room watching Judge Judy. I'm in the kitchen eating leftover sushi, and she yells, "Oh, girl, you gotta hear this one." A man was arrested for running a theme park, and when they said, "Where's your license?" he said, "My dog ate it." Oh, you can't make this shit up. Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on her Prosecco, makes fun of all the weirdos, and then I hear her shout, "Girl, you gotta hear this one." Mama loves to laugh at how absurd life is, says it's all a comedy and I'm her audience. And I love the way she makes fun of the world. She said, "You'll never guess who's with their girlfriend. It was a man who didn't get us out of the bed. He said, I've been through hell and now I need some help. You just can't make this shit up. You just can't make this shit up." Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout, "Girl, you gotta hear this one."
All right, guys, how you doing? Let's get straight into this. This is part 2 of Jeremy Hales' appeal document. Oh, and yesterday we talked about a lot of stuff, but didn't really get into the document. It's hundreds of pages between the two of them. We're not going to read it word for word. We're going to hit the highlights. But remember, nothing else matters if you can't get past the judicial immunity. And once again, just like yesterday, we're not arguing about judicial immunity or prosecutorial immunity, absolute immunity, whatever the hell you want to label it these days. We are not arguing about it because I think it sucks. I think it should be abolished in all 50 states, except for the limited scope in which it was supposed to be around, which was from 1607 England. Thank you to the British for our immunity. We can blame Spawn Trooper, especially since he's not here to defend himself. However, with that being said, we are going to get straight into this damn document. But first, I'm going to say hi to chat. Title, thanks for being my super mod. Yes, get the F-bomb. I did pin it to the top of the chat, I think. Tallow truth, it is my favorite thing in the world. I have F-bomb. I use it all the time. It's helping me get rid of this WTF line in the middle of my forehead. I use it to get rid of calluses and open wounds. I use it for everything. It's amazing. It's absolutely amazing. Jeffrey, how are you? Roy, good to see you. Tammy, as always, great to see you. Andrea, how are you? And I'm sorry if I don't get to everybody. It's got a lot of documents. I'm tired. It's been a day. Toddler is going to be a toddler. Let's put it that way. So if you hear her running and screaming, she is fine. We are just having a day. Gail, good to see you. The Artemost, hey, I hope you are doing well. Prayers to you and your family. Let's see, who else? Snipe Hunter, good day. All right, and JKD Buck, as always, yes, my second channel. If you don't catch my second channel, we are doing a chronic pain series every Sunday night at 9 p.m. Eastern time, where this Sunday is going to be about chronic pain and why chronic pain increases if you are a woman about a certain age. All right, and Robert Ward, good to see you. Let's get into this document. This is where we left off yesterday, talking about section 2265. We are having growing pains with growing baby squid. We're just having where a toddler is going to be a toddler. Like, you know, she just does what she does. Like, she's just going to be 3, and she is a great child, but sometimes she truly acts like she is 3, and she lets everybody know that she is 3. So, all right. And yes, my second channel, I would like to get my second channel up to like 1 million subscribers. It's never going to happen, maybe, but that would be everybody needs that information. And excuse me while I chug some caffeine. All right. Yesterday, as a recap, I did link it in the description of the video if you want to go back and watch on Replay Crew. 2265 and 1983 are the statutes that are in play here. We're going over right now what 2265 means. We are just going to grace over a lot of it because a lot of it is repetitive. We are going to skip things that we already know because it's the one thing that I hate about the lawsuits, and this case especially, is a lot of this stuff is regurgitated. I understand that it has to in the paperwork for judges who have never seen this case before. You're trying to tell them everything. However, I am so sick of regurgitated bullshit every 5 minutes. And like, that's why I can't do the Facebook pages, because it's the same thing on multiple pages. And it's like, I understand not everybody is in every group, but I feel like I'm in an echo chamber and I just can't do it. So, oh. Hey, Paramount Performance. They always told us, oh, the terrible 2s. It's really the terrible 3s. Yes, we refer to that as 3-nager around here. 3 going on 13. Yeah, Fearless 4 is in about 4 months. Oh, yes. And I will miss this when she is older. I know I will. But I have to say, potty training is the hardest thing I've ever done in my life. I have been in the military. I have worked as an occupational therapy assistant in an acute care hospital, in ICUs, in cardiac floors, in neurology floors, in inpatient rehab. I have deployed multiple times as an avionics tech. I have done a lot of things in my life. I have worked on the ramp at a major airport in the US. Potty training is the hardest freaking thing I've ever done in my entire life. Ever. Just saying. And with number 1, we are good. Sorry for the mama tangent, but I am first and foremost a mother. So every now and then, some people hate me for it. Some people go in my comment section, just get to the shit. Stop talking about being a mom. Well, that's me. Sorry. You get what you get. I am not everybody's cup of tea. But like this withholding your bowels because you don't want to poop on the toilet thing is like, it is like so getting me so worked up that I just, oh my goodness. And hey, Debbie Webb, how are you? And potty training is all about control and efforts. So yeah, I don't. The problem is I don't force her. The problem is when she withholds for 8 or 9 days, it becomes a medical issue and no longer a control issue. And that's what we've been dealing with. We've had trips to the ER. We've had trips to the pediatrician. We've had more trips to the doctor. The last time she went to the doctor because she was sick, she was 6 months old. She is 3.5. We've gone to wellness checks, but the last time I truly had to make an appointment and take her in because she was sick, she had COVID at 6 months old. That was it. And hey, Randy, how are you? It's a thing. And she's stubborn like me. You know? Speak of the devil and she shall appear. All right. Getting back into 2265. You want to read about 2265? No? Okay. You want to call Daddy?
Call Daddy.
All right. Well, and here we go with the lipstick. All right, it means that 2265 unambiguously benefits individuals protected by protection orders, creates an enforceable right under 1983. And 1983 is the civil rights statute. Bluey is not on. I think it is Destination, not Destination Fear. Destination Fear was their TV show on Travel Channel or Discovery. They have a YouTube channel now. Fear Fact or Project Fear. It's Project Fear, one of the episodes from recently. So, the statute contains rights creating language. And remember yesterday there was the 3 areas that they had to hit. Whoever wrote this did a really good job of making sure they hit exactly where they needed to hit. The one thing that I would critique, armchair non-lawyering would be to yes, you have to go this way though. Okay. My one critique would be the fact that if you can't get past the prosecutorial immunity, you are nowhere. So why not stress that first? But Heidel, I don't think this was either one of them. If I had to take a shot in the dark, and I have no insider knowledge, I don't talk to anybody. I don't talk to anybody that knows anything insider knowledge wise. I would say that this was not written by either Randy or Doreen. Just based on how it's written, I would say this was written by someone who is an appeals attorney, who specializes in appellate law. That's just me based on reading this and then reading other appeals in other cases, like the Maya Kowalski case and that appeal. This was done by an appellate lawyer or someone who's done appellate law before. And I don't know if that's Randy. That's just my personal opinion. I could be wrong. I don't ever claim to know, like I said, the last time I had a conversation with Jeremy was 3 minutes on my channel in January of 2025. So I don't know. Just a guess based on the way it's written. What do you mean they're borrowing stuff now? Well, if I'm going to write an appeal, you did it? It didn't work? If I'm going to write an appeal, I'm going to make sure that I get an appeals attorney who is proficient and has been in front of an appeals court before. I would not, even if I was Randy, okay. Even if I was the best, you do it. You want to talk to him? Here, I gotta work. Hold on. She wants to call her father, and she wants me to hold the phone while she talks to her father. Not possible. She knows how to do it. She just more is infatuated with the fact that she knows how to call her dad than actually calling and talking to him.
No, Daddy. So, no, Daddy.
I seek your father every day, baby.
No.
Okay. Then I'll put the phone back on the charger. Oh. See what I mean? Toddler. Today we're just toddlering all over the place. We've since you love immunity so much, Supreme Court yesterday affirmed immunity regarding a lawsuit against a trooper for breaking her arm during the protest she was involved with. Okay, Jeff, just pushing back on that a little bit. I don't know exactly what that case all involved, but if you're getting out of pocket during a protest, that's a little different, and you're interfering with public safety and you fuck around and the cops make you find out, that is a little different than this. I'm that one I can totally understand if I have to look more into it. But those people like to sue people all the time because, like Renee Good's family, I'm sorry, she accelerated towards an officer and hit an officer and expected there not to be consequences to that. So you fuck around and you're going to find out. That's a little different than what Jeremy's arguing here. There two different scenarios in a just stirring the pot. Yes, I know. However, speaking of cops that have a sense of humor, if y'all want to laugh, so this was shared by my local police department because they have a sense of humor. If you know, you know. That picture was shared on Facebook by my local cops. And the comment section ran wild. Usually they get a couple hundred comments on their funny posts. This one, they have like 2,000 comments. It is so funny. So, yep. Yeah. So there's that. Welcome to the, I live in the South. We have a good old boys club kind of here, but we are not as bad. And for those of you who have asked me why I didn't cover Afro Man, I have family there, less than a half an hour from that courthouse. I am not going to risk my family and some of my best friends in life retaliation because I made fun of those cops. Although it is tempting, I am not going to risk. It's why certain people don't talk about lawsuits and stuff in their own state and judges and stuff. Well, I have family and very close friends that live very, very near to Adams County. Some of them in Adams County. I'm not touching that one with a 20-foot pole and a sandpaper condom. Just saying. Yeah. Well, I was going to talk about that. I was going to mention it on Friday. Yeah. This is the problem with this lawsuit is, like, these cases. There's too much drama with all this stuff.
Mama.
And I just can't do it. Love you. So, there's just certain things that, you know how many CPS calls I would get for that, even though it's a joke? Just saying. All right. So, under the standards established by Supreme Court and applied by 11th Circuit, 2265 satisfies all requirements for 1983 enforceability. All right. So, here's the next thing they argue. It was a joke in the military. Uncle Sam likes to screw you with a sandpaper condom and no lube. Welcome to the military. That's more like it. That's okay. We were just sharing pictures of lemon pound cake. Bye, Curbless. All right. The district court erred in dismissing appellant's procedural due process claims by misapplying the legal standard, conflating substantive and procedural due process doctrines, and failing to accept well-pleaded factual allegations as true. Here's the thing. So many things to like discuss about this, but like it's the due process is a little bit of an issue for me. And I don't think it's gonna stand. My personal opinion, unpopular opinion as it is the immunity is the check. It's the immunity, because we all know he screwed up. However, did he screw up enough to meet the level of getting past the immunity? Everything is about immunity. So all this is like nice and fluff and adding to it, but I don't think it's as important as talking about the immunity standard. And they still haven't. We're 37 pages into this document, and we still haven't got there. When the complaint's allegations are properly evaluated under the Iqbal-Twombly plausibility standard and controlling 11th Circuit precedent, appellants have stated a facially plausible claim for violation of due process. And then he goes into how the Due Process Clause protects individuals from arbitrary government actions by safeguarding fundamental liberty interests such as bodily integrity and freedom from harm, originating either directly from the Constitution or from a state law, and provides heightened protections against government interference with this right. Now, I have never heard of that. All right. 14th Amendment Due Process Clause provides no state shall deprive a person of life, liberty, property without due process of law. The Due Process Clause protects individuals against arbitrary and unreasonable exercise of governmental power. Appellants are alleged a protected liberty interest in their personal security, bodily integrity, and freedom from private violence. Specifically, appellants alleged they are protected persons under 2 valid orders of protection issued by the state of Ohio, designed to ensure their safety and security. I know. However, my thing is, if my brain just goes to pleading first what is most important, and nothing else matters if you can't get past the immunity. Because all of this could be argued great, but if he hides behind immunity and is protected by immunity and they can't get over that immunity hurdle, all this was a waste of reading. I just felt like that should have been first and foremost, and the most effort put into getting over the immunity. Yeah, like a loan application for college. Yeah. I never had to take a student loan. Uncle Sam's dime. The Ohio Protection Orders and federal law both recognize and provide procedural frameworks to protect individuals' pre-existing constitutional liberty interests in personal security, with federal law ensuring these protections are upheld across state lines. Ohio Protection Orders do not create the liberty interest, rather they recognize and provide a framework protecting pre-existing constitutional liberties interest in personal security. The issuing court had jurisdiction over the parties and subject matter under Ohio law, and they were issued after a hearing. It's not that they were like, I could see if they were temporary, but still, that's a stretch even for me. But like, I could see Dan Owen, because it's super easy to get a temporary restraining order. Almost anybody can do it. It's really hard to get a permanent one because you have to provide evidence and proof. Whereas a temporary, in the examples that I've personally witnessed with people, it's my kids are scared of my ex-husband. And all of a sudden you have a temporary restraining order with no actual evidence. And that is true too. That is true too. However, that's just like I said, it's just my personal, my personal opinion. But opinions are like assholes. Everybody's got them and they all stink. So I'm not saying I'm right. I'm just saying That's what I'd prefer if I was reading this as a judge. But like I said, not a lawyer, not a judge. So at the end of the day, my opinion is just my opinion. It's judicially issued orders. Federal law reinforces this framework through 2265, which mandates that protection orders issued by one state shall be accorded full faith and credit. And see, that's the key word. And I think I talked about this when I actually read the document and read the full faith and credit clause, is there's like, they use words like may and shall, may or may not kind of situation. It may be enforced, but it may not be. Whereas like shall, you have no choice. It's It is. My friend did not see his kids for over 60 days because his ex-wife is a little, she is BPD, among other things. Yeah, to the point where they've actually asked for her medical records to be entered into court records because of this situation. Because she has a habit of being a habitual liar. Yeah. So I think though, I'm not gonna lie, I got off of the stream yesterday. I went to make sure the little was good, changed, cleaned up the house before Mr. Squid got home. He got home and I left. And I got home at like 9 o'clock last night. So, and when I got home last night, social media and working, doing anything on a computer was not on my agenda. A lot of things were, but that was not one of them. Hey, Tammy. All right. Deprivation of state-created rights can still violate procedural due process if constitutionally adequate procedures are not followed, as illustrated by the appellant's claim regarding deprivation of their liberty interest in safety after judicial protections were ordered. The fact that this is all one sentence, it's like wholly run-on sentences. Hey, Muscle Lady, and hey, Starzy. District court's orders did not explicitly address whether appellants alleged a cognizable liberty interest. Instead, the court focused on whether the appellant stated a substantive due process claim and concluded they had not alleged facts to support such a claim. This analysis fundamentally misapprehends the nature of appellant's procedural due process claim. As the 11th Circuit explains, deprivation of state-created rights that do not give rise to a claim for violation of substantive due process may nonetheless give rise to a claim for violation of due process. All right. Case law, just talking about more about duty to protect them from violence. Appellee Owen deprived them that interest without constitutionally adequate process. This is quintessentially a procedural due process claim. And you know what? Like, we all know, and this is always this is why I hate immunity, because it allows people in a powerful position to think they are invincible. I have to go do some cleanup work. I will be right back. Y'all taking a quick intermission.
Our hearts beat to the city streets. We began to feel the fire. We rise like tall buildings as the chemicals they take us higher. The night's young, it has just begun as she puts her hand in mine. We wanna chase the night never stop. Every shot from the top, we're gonna be two hearts running wild. Now the morning is the afternoon. We lay awake in bed.
Hey guys. Sorry, still have wet hands. We're working on it. We're getting better. We're just not all there yet. All right. Yeah, I really haven't been either. I have pulled back on all of the drama, talking to people who are involved in the drama. Don't care. People have DM'd me and I've said, please don't, kind of situation, because the court cases is really all that matters to me. Hey, Lori. So, all right. Procedural due process serves as the essential constitutional safeguard that protects individuals from arbitrary government action by guaranteeing notice and meaningful opportunity to be heard before any deprivation occurs. Breathe. Whereas substantive due process merely prohibits certain government actions outright without offering the procedural protections that ensure fairness, transparency, and the opportunity to contest erroneous deprivations before they cause irreparable harm. One sentence. Like, you couldn't have figured out a way to make that easier to read. I'm just saying. Procedural due process and substantive due process are distinct constitutional protections. Procedural due process affords notice of a possible government deprivation and a meaningful opportunity to contest it, usually before it is imposed. All right. By contrast, substantive due process bars certain government actions regardless of the fairness of the procedures used to implement them. A violation of substantive due process is complete when it occurs. No amount of process can justify its infringement. Tammy Main, thanks for the $10 super chat. Squid, 75 watching, only 46 likes. I challenge you to like or super chat. I appreciate these super chat. I also would appreciate hitting the like button and sharing it, because when I started cutting back on covering this case, now it's funny because, like, people who used to always be here don't show up anymore. And it's like, oh, you know, and I lost like 40 subscribers. So it's like, tell me that you don't care about me. You only care about the content, or the certain content. It's just funny. Yes. Thank you for making sure I'm not working for free. All right. District Court erroneously applied the substantive due process standards to what was fundamentally a procedural due process claim, where the proper inquiry is whether a state actor deprived individuals of a protected liberty interest without constitutionally adequate procedural safeguards before that deprivation occurred. I like that they separated it out. That's true too. That's true too. And I appreciate that, Taz. I just know that I'm not everybody's cup of tea, because I will call bullshit whenever I see it. Doesn't matter what side it's on. So, but I read something yesterday that when you can tell who's the narcissist and who's the victim, and this was just a Facebook reel, but it was like, when the narcissist, or when the person who's standing alone while everybody else like cheers on and chants and supports them, that was me in February of 2025, when someone attacked me. And now that person is attacking really popular people, and all of a sudden it's like, oh, everybody seems to care. It's like, where were y'all when I was being attacked? Oh yeah, I was told that I was wrong and enforcing boundaries were a problem. And when I did talk about it, I was making people uncomfortable. Well, I hate to say I told you so, but I told you so. Because now people who sat by and idly by or cheered and encouraged people to keep attacking me are being attacked. And why I have no ill will for people, karma keeps receipts. And she's collecting some debts right now. It sucks, but it happens. District court's analysis demonstrates a fundamental confusion between these distinct doctrines. This court cited DeShaney versus Winnebago County for the proposition that the substantive due process analysis, it generally states affirmative act restraining liberty that gives rise to substantive due process, not its failure to act to protect citizens from harm. All right. District Court also cited L.S. Hernandez v. Peterson regarding when conduct by a government actor rises to the level of a substantive due process violation. These authorities address substantive due process and the state-created danger doctrine, doctrines that govern when the state has an affirmative constitutional duty to protect individuals from private harm. But appellants did not allege a failure to protect claim or assert that the state had an affirmative duty to shield them from private violence. Instead, appellants allege that Appellee Owen, acting under color of state law, deprived them of a recognized liberty interest without providing constitutionally adequate process. It's completely true, because I told that certain person that to no longer contact me because they tried to drag me into their drama, and I said leave my name out of it. They didn't, and all of a sudden I became the worst person in the world. I was stealing content. I was this, I was that, I was threatening, when really I said please leave me alone. No longer contact me and forget you know me. And I became public enemy number 2. Spawn was public enemy number 1. But I was public enemy number 2. But I was the first woman that this person attacked. And then this person went after a bunch of women, older women than me. And it became a big thing, which, hey, I don't like that person attacked women, but they weren't the first women that he attacked. Just saying. Just saying. So, if you know, you know. If you don't know, it's a thing. But it's why I don't stream with a lot of people, because people be shady. The district court's reliance on DeShaney and similar substantive due process authorities was therefore misplaced. Yeah, you were attacked when you don't agree with them. Screw that. There was a Discord server with I guess a file on me trying to look for evidence that I was stalking them. It's like, just leave me the fuck alone. Like, leave me the fuck alone. like, just leave me. Yeah. Just leave my name out your mouth. Like, you're worthless to me. Like, you're worthless to me. Like, when I shut off my computer, like, a lot of people, it don't matter. But I live rent free. Oh, my favorite color is blue, by the way. So when y'all are redecorating those apartments I have in your heads, my favorite color is blue. Paint color. I have some swatches if you want me to show you. So yeah. Yeah, and that's the thing. Like, that's the, yeah. I just want to be left the hell alone. I want to run my channel the way I want to run it. I don't want to have drama on my channel. And that's why when people bring drama, I just eliminate them from my life and I forget that I ever knew them. And apparently that pisses off people. Yeah. That's the thing. Hating takes too much energy. There's a phrase that I saw a few years ago that someone sent me. When I say a few years ago, I mean before YouTube. I mean like a decade ago. It says hate only corrodes the container it's stored in. When we hate other people, the only people that it affects is us. Most people don't know we even exist. So like going on about hating them, it's like no one cares. No one cares. And especially after I turn off my computer at night, like I don't lose sleep over someone on the internet not liking me. That's why I find the hater comments like, oh, you spent too much time with your daughter. What? 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 And I will, and this right here, and y'all will hate me for this right here, but this is why only me is allowed in my chat. Because only me 2 years ago called me a bad mom. Only me actually apologized to me for that comment when I called him out on it. I called him out on it like 6 months ago. He actually apologized to me. And that is why he is allowed in my chat. Not because I want to create drama, not because I'm trying to start shit. It's because he actually apologized and showed me some damn respect. So I'm going to show basic human respect back. That's why. So yeah, hating takes too much energy. I don't got time for that shit. Oh yeah, it's 100% true. And I don't mind. I generally don't talk about it because it doesn't matter, but it's funny because it's only funny for this. When he attacked me, I made a response that I made private because I got a little aggressive with it. But it made people uncomfortable, the fact that I was responding to being accused of crimes, like threatening people. And when that happened, I lost like 30 to 40 subscribers because people believed what he said. And now some of those same people who took sides and said that they agreed with what he said and went from liking my channel to thinking I was the worst person on the planet and I was this awful person, whatever they thought, I don't care, are now being attacked. So I have no ill will towards anybody, and I have made amends sort of with these people. I'm civil with all of them. However, I just kind of want to go, see what I told you a year and a half ago? Almost like I could have called this shit. Almost like I could have seen this shit coming because it happened to me first. Don't say I didn't warn you. Like, don't say I didn't warn you. So, doubtful. Not very well. Not very well. Not very well. I don't think. Like, quite aggressive, no way. Yeah, well, you know. This is my aggressive channel, or where I say what I think. My other channel is where I really say what I mean. My other channel is the professional version of me. This is the I get to tell everybody what I think of certain issues, and give you my honest opinion. That is my professional opinion on the other one. This is my commentary channel. That's my professional channel. However, I will say, just because I am, and I do have 10 letters of credentials behind my name, COTA, CLT, and CES, does not mean I give medical advice, and I sure as shit do not give mental health advice. I could lose my license for that, and I am not that kind of person. I appreciate someone trying to set me up, but I'm smarter than you. Instead of investigating probable cause to arrest for violating the Ohio protective orders, Appellate Owen investigates the validity of the judicial protection orders that are valid on their face and advising law enforcement against enforcement, all without notice or opportunity to be heard, thereby undermining their protected liberty interests and depriving appellants of procedural due process. Appellants allege that Appellate Owen, as a Florida assistant state attorney, unilaterally refused to enforce a valid judicial protection order and instead initiated an investigation into whether Appellant Hales committed perjury in obtaining those orders. In other words, instead of investigating whether there's probable cause to arrest for violating the Ohio protective orders, Appellee Owen investigated the validity of the judicial protection orders. That's the problem. And I see why that is a problem. And I am never going to argue that that should not be the case. My whole thing is the immunity, because if he can hide behind immunity and cover his ass with immunity, none of this shit matters, and which sucks.
Mommy, it's
It is? How about you call him back? Yeah, the camera's been acting funny at work these days. Here you go. Try again.
No.
Okay, don't try again. And let me get to these super chats. JKD Buck, keep up the good work. Thanks for the $2. I appreciate you. JKD Buck used to be a mod for Legal Vices, and Legal Vices was one of my biggest cheerleaders when it came to my YouTube channel, and JKD Buck is stuck with me for the rest of eternity. And Tammy Main, thanks for the $5 super chat. Squid's other channel has helped me find new ways to enjoy life with my challenges and pain. I'm so glad to hear that. I really want that channel to thrive. That is my baby. That's my career. That's my heart and soul. And Taz, thanks for the 5 gifted Squid Proco memberships. As always, you are very much appreciated on this channel. We've kind of talked about this before, and I understand that. I understand where you're coming from, and I read through it, but no county that I can find actually knows what that is. And Robert Ward, thanks for the $2 super chat. Owens thinks he's untouchable. Yeah, and that right there is the problem. And I'm not sure if it's the good old boys club. That does exist. Once again, perspective. The good old boys club exists, but I'm not sure if he thinks he's untouchable because of the good old boys club or just because he thinks he's the smartest person in the room. I think it's because he's the smartest. He thinks he's the smartest person in the room, and he has friends in high places. It's like not the Levy County good old boys club, but it's like the lawyer good old boys club. It's that fraternity that not a lot of people get into kind of a situation. Because not everybody becomes attorneys, not everybody becomes a state attorney, and when you become a state attorney, generally you have higher ambitions. So I think part of it is he thinks he's the smartest person in the room. And as we've discussed from a psychological standpoint, when you think you are the smartest person in the room, nothing goes well. Nothing goes well. And hey, Southern Red Sox girl, thanks for becoming a member again. I have high friends in places. I have friends in low places. Yeah. Appellant alleged that Appellee Owens is a Florida state attorney, refused to enforce. Do appellants allege the conduct effectively nullified the protection orders without any process whatsoever? All right, and we've all seen this. Appellee Owen cautioned against enforcing the injunction, as stated to appellant risk. See, and this is my thing with Jeremy. And he might have a plan. Like I said, I don't know. I don't talk to the man. This is my situation. This is just my opinion based on documents and what I would do if I were in that situation. I would have sued the sheriff's department first. And I say this because at the end of the day, his immunity is harder to get over than theirs. Because at the end of the day, they're not supposed to make laws. They're supposed to enforce them. And the fact that they didn't enforce them, to me, might be, like I said, not a lawyer. This is just my personal, logic process. I thought it would be a little easier to sue the Levy County Sheriff's Office because their hurdle of immunity might be lower than an attorney. Kind of a situation. But that's just me, because their whole job is to enforce the law, not make law, not interpret the law, none of that. Their whole thing is to enforce the law. That was part of the issue with COVID and all the stupid things that were being, the cops were like, well, we're just supposed to enforce it. Here we go. You're just supposed to enforce it. Somebody else is supposed to do the investigating. You're just supposed to enforce it. Like, it's the situation. Like I said, my personal opinion, y'all can take it, leave it, Yeah, I'm just saying that if I were, like I said, my thought process just goes them first, because then you could probably get them to flip a little easier than you could get, situation. Hey, Karen. Still, it's still not there. It's still not his job. It's still not the DA's job to tell them what not to enforce. That's the Florida legislature and or the county commissioners or whatever the local government in Levy County would be. But other than that, it's the Florida legislature, not a state attorney. And I completely agree. I'm not saying, like I said, it's perspective and it's process. It's where I would have gone first, because I think the cops would have been easier to get over that hurdle of immunity than going for like the head of the snake kind of a situation. Yeah, but to me, if you're going to file a lawsuit, that would be the person that I would sue first. Just saying. Like I said, and this is all just my process, what I would do. I'm not saying that I'm right and Jeremy's wrong. I'm just saying, what about this? Think about it in a different perspective, because we don't always have to agree on the process to agree on why something is happening. Like, we all agree that Dan Owen is a dick. And that's not an alleged situation. That's a fact. However, with that, we all think he's a dick. But the best, and I'm also petty. So I would get everybody to flip on him to save their own skin, because I'm petty and underhanded like that. Hence why, like Lips, heard there might be a new bankruptcy there to check out. Yay, I get to make fun of Lips again. Instead of suing her for defamation because she doesn't have anything that I can take, I'm just going to make fun of her dirty laundry on the internet and let everybody see the bullshit she spews. Because who am I to not be petty like that? So I want to introduce chaos and make people start turning on each other. And then sit back with popcorn and watch the shit show. That's how I get my shits and giggles. That's just me. I am petty like that. I will go for the lowest person that I think will start talking bullshit. And you get them to start infighting. And there's nothing better to get people to turn on each other than when lawsuits get filed, as we've seen, as demonstrated by the the Hales ecosystem. When lawsuits start flying, people start infighting. However, yes, right, Tammy, I'm one of those people that I will not, I'm not going to waste my money to sue somebody who doesn't have anything. However, I will embarrass them on the fucking internet And when you trauma dump in legal filings and you shit yourself in legal filings, I will show everybody your shit stains. You know, that's the kind of, so that's the kind of petty I am. But see, and that's why I would have gone after the sheriff's department first, because you get the deputy who's only been there like a week, hypothetically speaking, that hears things, says things, when he knows that he's being sued, he's like, I had nothing to do with this. He did. And then all those people start fighting to save their own asses. And then I sit back with popcorn and a Celsius and just watch the shit show ensue. I don't know if I agree with you. I think there will be an oral argument, so it won't be thrown out next week. So we'll just dispel that one right away. I think there will be an oral argument, but that prosecutorial immunity will be hard to overcome. That absolute immunity will be a damn hard hurdle to jump. And that is not talking from someone who doesn't think that Jeremy has a point. That's just someone who thinks as a realist. Because prosecutorial, or, that absolute immunity is fucking bullshit. Yes, but unfortunately, immunity in Florida, you can ask him. Immunity in Florida is a very high hurdle to meet. But I do think there will be oral arguments on this, and I really hope that they are on the website. Moreover, all of this is done without affording appellants any notice, hearing, or opportunity to be heard. This is precisely the type of governmental action that procedural due process is designed to address. Appellants adequately allege state action by identifying Appellee Owen as an assistant state attorney employed by the state of Florida who acted under color of state law. Allegations the district court acknowledged without dispute. There's this. And this is my thing with Dan Owen, is when someone does a 12B6, they generally only say, well, you failed to state a claim. You failed to state a claim. They never actually say, well, I didn't do anything wrong. You just say, well, they couldn't prove it. And if I'm remembering the motion to dismiss correctly, Dan Owen never actually said he didn't do anything wrong, which to me is a problem in the long run when someone does that. To anybody who files a 12B6 motion, like I said, not a lawyer, never claimed to be, but like that's one of the loopholes that I would use, as they are here, with when filing an appeal or another motion. I'd be like, well, he never actually said he didn't do anything wrong. He just said that I messed up and didn't argue it right. He never said that he was innocent. So, Bye, Heather. Well, and that's the thing. It's an appellate court. So I believe the 11th Circuit is the same as most appellate courts. It's a panel of 3 judges. So it's not just one judge. It's 3. So not just Florida. Not just Florida. Every state and our federal government need to be downsized significantly and replaced with people who actually give a shit. So, second element of procedural due process requires state action. Appellants clearly alleged state action. The complaint identifies Appellee Owen as a state official employed by the state of Florida and an assistant state attorney who was acting in his capacity as a state official when he refused to enforce the protection orders. District Court did not dispute that Appellee Owen was a state actor. Indeed, the court acknowledged that Appellee Owen is a state official employed by the state of Florida. These allegations satisfy the second element. Complete absence of notice and an opportunity to be heard. As it is deprived appellants of fundamental liberty interest without any constitutional required safeguards, contrary to established Supreme Court precedent. In 30 years, I've only seen one case in pierced immunity just recently in Osceola County regarding a shooting. I'm sure it will be appealed. Wow, but a federal district judge shot down immunity. I mean, he's my Florida law enforcement expert. So generally when he says something, I tend to believe it because he has the knowledge and the work experience to back it up. And he usually sends me links to back it up as well. He's got stories. Procedural due process requires at a minimum notice and an opportunity to be heard. Hi, Debbie. If there has been a deprivation of protected interest, the court must then determine whether the process provides was constitutionally adequate. And here's the kicker with this. The court must, not a state attorney. Well, there's no laundry list of specific procedures that must be followed to protect due process. The analysis of the U.S. Supreme Court's prior decisions identified certain procedures that are typically required before an individual can deprive of a property or liberty interest. In all situations, court require fair procedures and unbiased decision maker. All right, to determine procedural due rights process or process rights, courts apply a balancing test established in Matthews above, which examines first the private interest that will be affected, second, risk of erroneous deprivation, such as interest through the procedures used, and the provable value, if any, of additional or substitute procedural safeguards, and finally, the government's interest, including function involved and the fiscal and administrative burdens. Discussed that yesterday. I really don't care about the money. All right, so we're skipping down to the next part because we're still on only page 50 of this document. The complaint alleges Appellee Owen sent an email October 30th, 2023, requesting documents to determine whether Plaintiff Hales committed perjury in obtaining the protection orders. Appellee Owen stated, I want to see if Hales committed perjury in the petition. Specifically, I want to see what representations he made in regards to Preston and Cook's residence. Owen then refused to enforce the orders, and Officer Williamson's report documented that Appellee Owen would caution against enforcing this injunction. Here's my only problem with this and the way this is written and the way this the reported documentation. Right here, would caution against. That was the other thing that made me think he should have gone after the sheriff's office first, because would caution against is different than do not enforce this. And there may be more emails. However, if you're, my opinion, totally just my opinion, if I'm going to put something in an initial complaint, it is going to be the smoking gun situation. I would not put would caution against. If they had something where he said, do not enforce this, I would put that. So this is where I'm like, I really wish that was not in there, because would caution against enforcing this injunction puts it back on Williamson. It takes it off of Dano, because at the end of the day, anybody can say anything. I don't believe that this person did this, or I don't believe that this person did this. That still shouldn't stop the law enforcement officers from applying the injunction, or, you know. So the fact that he said Owen would caution against enforcing it is different than saying do not enforce it. There's my like why I would have gone after the sheriff's office first. You know, hey, Nanny. Hey, Malin. That's my, that to me is like a stopping point where I just can't get past it, because technically he did not say do not enforce it that we know of. And Jeremy might have something, but if I'm going to put that and try to convince a judge why this needs to move forward, I would have put that. Oh, I completely agree. That I totally agree. I don't think it's accurate. And I think even if he was questioning it, and worst case scenario, okay? Worst case scenario, hypothetically, say Jeremy lied, blah, 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 and they're investigating and they find out that someone lied. Well, you're still supposed to enforce it while you are investigating. Like when you have a TRO versus a full protection order. The temporary restraining order will provide you protection while they are investigating a full situation. So you still have to enforce the TRO while they are working on the full protection order and the hearing and all that stuff. If he questioned it so much, okay, fine. You think Jeremy lied, whatever. That's your personal freaking opinion, but you still have to enforce it while you are doing whatever shady shit you want to do. Like, I believe there's one email that wasn't seen, maybe in that one. Well, see, and that's where I would be like, if I'm going to put it in, if I'm going to convince a judge who has no idea what's going on, and this is part of the reason why I don't pay attention to all the 900 other bullshit things that are going on in these cases. One, I don't have the time. I don't have the attention span. And three, when I'm looking at documents, when I know behind the scenes stuff, I look at documents differently. Knowing outside information makes you interpret things differently. So one of the reasons that I really don't pay attention to reading screenshots from other that people post on the internet or Facebook or whatever is because it shapes how you view these documents. And I've always wanted to come at this from a judge's perspective and only pay attention to what the judges will see. So the more I know about the background, the less objective that I can be. Obviously, the facts lead me towards one side. But when you go to other people's streams or whatever, and they're showing emails and this and that and talking and giving their opinions and this and talking to Jeremy, and it shapes how people view the documents. And that's kind of what my whole mentality is. Because if I pay attention to all the other stuff, I will not be me. I will be swayed by what I hear. This person said this person said this person said this. So I tune all that out. I don't have the attention. Yeah, it promotes bias. And that's really what and fine. But that's still not on the cops to make that decision. That is for the cops to arrest or write reports, and then Jeremy to go above and beyond wherever is next in the prosecutorial chain of command and file that. That would be a huge freaking lawsuit that I think would actually be better than this one. Because that is the cops doing their job and him not doing his job. Versus this is, I see their point and I agree that he acted in a shady manner. Totally agree. But does it meet the level of going against the statute, or is it just shitty behavior? Because remember, being an asshole is not necessarily an illegal act. Not everything that negative that happens, unfortunately, not every little bullshit thing that people do. And yes, we want vengeance, and yes, we use the law to get our justice, but not everything is suable offense. Sometimes shit just happens, and sometimes people are just assholes. But being an asshole is not necessarily a suable offense. But, yeah, if a petitioner is found to have lied to the authorities in the state court, it occurs. As I've said, it's not my job to investigate or even care if document looks shady. My job is to enforce a valid order. Yep. Hey, Rickles. Perhaps if the order was enforced and someone was locked up, further nonsense may have been stopped. Inaction emboldens all the others. Yes. Yes. Mhm. And I'm not saying I know what the next step would have been. All I'm saying is I think it would have been a better case that there's documentation that they violated the order because the cops actually did their job. And now we have documented proof, hey, they violated and he didn't do anything about it. That's a violation of my, constitutional rights of the 2265, the fair, you know what I'm talking about, full faith and credit clause. Yeah, I'm wondering if someone that doesn't have any contact with Jeremy would do a FOIA on what they'd do. Who's the root of the non-enforcement? This reminds me of Comey telling the American people he feels there's not enough to prosecute Hillary. It wasn't James Comey's place to make that call. Yeah. I would too. Good thing being an a-hole is not suable, or my husband may be in a lawsuit this morning for not picking up his dirty laundry. Mr. Squid is very particular about where things are in the kitchen. Well, he scoots back next to our island is our garbage can, but I have it moved off the wall again about an inch or two so that when you open when you hit the foot pedal and open the garbage can, it doesn't smack against the cabinet. He moves it back every time and it pisses me off. Like, he does it on purpose. How does Owen defend against not enforcing a court order? Hide behind absolute immunity. That's how. And as Jeff has said multiple times, and told me and discussed with me multiple times, in Florida in particular, and I can't speak to every other state, I can't even speak to Georgia, but in Florida, from what Jeff has told me, getting past absolute immunity is very, very difficult. In his 30 years, he put a comment earlier, in his 30 years, he has only seen one instance of someone getting past immunity, and that was recently in Osceola County. If I were an administrator with that county, I would instruct to make an arrest based on the order's language and let the state be the fall guy. Yeah. It's just, this phrase right here is why I would have sued the sheriff's office first. Because would caution against is completely different than do not enforce. And it's where that loophole language, that stupid loophole language where words matter and what specific words are used matter. And Dan Owen, being an attorney, has a little bit of sleazy way of using the English language to manipulate things. Whereas the Officer Williamson, probably interpreted that as we should not enforce this. However, when it comes to a lawsuit, would caution against is different from do not enforce. It's a slight difference, but very important when it comes to the legality of it. Yes, plausible deniability. Yeah. It's it's one of those situations where it's where language is important, and what you say is very important. Did you throw bacon against the wall to see if it stuck? Appellants allege that Owen deprived them of their liberty interests without any process whatsoever, without any constitutionally adequate process. Appellants allege that Appellee Owen unilaterally decided to investigate the basis for the protection orders and refused enforcement without providing appellants notice, a hearing, or opportunity to be heard. They allege Owen's decision to investigate the truthfulness of their statements and obtaining the orders effectively nullified the orders without any hearing or other process. These allegations satisfy the third element as appellant's plausibility, constitutionally inadequate process. Do you think the judge will tell Owens to enforce the order? You know, I honestly don't know. In Dose Reality, how are you? Hales has no restraining order, and so it's legal, but it does dampen his claims a bit and opens them up to attempting lawsuits where, sadly, in this day and age, one might stick. Yeah. I believe if Hales would have gotten a civil rights attorney and go that route, I believe things would be different. Yeah, and this is one of the reasons why the way this document is written, I don't think Randy or Doreen wrote it. And that's nothing against Randy or Doreen. There are reasons why in professions like medicine, like the law, that people are experts in certain areas. They're like, say, therapy, my world. There's people who specialize in neuro, people who specialize in geriatrics, people who specialize in pediatrics. You have a general knowledge of everything, but you get specialized in one area, and that is what you are good at. You know that better than most people. There are reasons why constitutional law is a thing. Criminal law is a thing. Criminal defense is a thing. It's people are specific because the area is so big. Nobody is perfect at everything. It's just not going to happen. This is why I think that neither one of them wrote this, because this was written by someone who has appellate, like Megan's sister is an appellate attorney. You've probably seen her a time or two, but like this would be like something that she would write. Someone who's been in front of a panel of judges for oral arguments. Appellate attorneys are a specific genre of lawyers, shall you say, that are specific in tailoring things to what appellate judges look for. Because the appeal process at the end of the day is not like when you appeal criminally, you don't appeal the guilty, not guilty. You're appealing the judge's work. You're basically critiquing the judge, whether the judge and the court made the right decisions, not the end verdict. It's a whole thing. Hey, Ricky Bobby. All these individuals screaming fraudulent PO need to realize it has a judge's signature saying it's a PO and until it's changed by the law. Yeah, and that's the thing. That's one of the difference between like a TRO and a full protection order. A temporary restraining order, anybody can get. Most people can get. All you need is a plausible claim, like my kids are scared of their father. All of a sudden you have a TRO, but then you have to go through a hearing and the scrutiny and provide evidence. Generally, things get overturned if there's no evidence. But in this case, there was enough evidence to not only get it the first time, but apparently get it renewed. With that being said, I think the fact that Jeremy got it renewed, and George too, will help this cause. Yeah, and that's kind of how I feel about certain areas of the country. Levy County is one. I think all the cases where there was protection orders should be investigated. Like Massachusetts, the Karen Reed thing. I think with the Massachusetts State Police, any like Proctor, any case that he was on should be, and where he got a conviction in that case, or where his arrest led to a conviction, needs to be scrutinized heavily. Every single case that he has touched in his career needs to be investigated again. And I think that needs to happen in multiple jurisdictions where there's proven police or prosecutorial misconduct. I think things need to be, because if there's one, there's more. Because if you're an asshole, you're generally not an asshole once. Generally, that's part of your personality, and it feeds into everything you do. And here and after, thanks for the 5 Squid Pro Quo memberships. I appreciate you very, very much. Yeah, Massachusetts State Police, definitely. Oh, yes. Oh, yes. Especially watching the Kelsey Fitzsimmons trial, or Kate, whatever, the Fitzsimmons trial. Holy crap. All right. Appellate Owens' unilateral refusal to enforce judicially protected orders and advice to law enforcement not to act on them. See, and this goes back to right here. This is where the wording of it gets funky to me, and this is just my personal opinion. Don't shoot the messenger, you know. Not to act on them, combined with conducting an independent investigation. He, in the phrasing that was used in this lawsuit, what is told to the judge never actually says not to enforce them or not to act on them. It says, would caution against. It's that legal loophole, Dan Owen, which makes Dan Owen look even sleazier to me because he knew what he was doing. He knew that if he was sued, this would be all that would be said, would caution against, which puts it back on the sheriff's department for not doing their jobs, not Dan Owen. Which is one of the reasons that make me think Dan Owen is even sleazier than we, and one of the reasons he thinks he's the smartest person in the room, because he did that shit intentionally. And I have no doubt that that phrasing was used intentionally. Because he never actually said in the wording that is used here. And at the end of the day, this is what the judge cares about. The judge doesn't care about emails that Megan and Tug or anybody else, Shizzy, Jeremy, whatever, show on YouTube. The judge only cares about what's in here. So if you have the evidence, why not put it in here? Not to act on them, combined with conducting an independent investigation. The independent investigation, totally don't agree with. But the wording that he used... Yes. You're bored.
Sorry.
We don't have any. Yep. Oh, and just remember, y'all, this was posted by my local police department. So I might live in the good old boys club part of the country, but my police department has a sense of humor. So the court reasoned that even if Appellee Owen asked for a copy of the documents and pondered whether appellants obtained the orders unlawfully, that does not nullify any valid order and does not preclude a court of law or law enforcement from acting on the orders. And that's what I was saying, and I said yesterday. Just because you don't agree with them, and we saw this in 2020 a lot, cops doing things that they didn't necessarily agree with, but had to by state doctrine or, you know, statute. But you heard them use the excuse all the time, well, I'm just here to enforce it. It's not my job to say whether it's right or wrong. So while you can ponder it, and even if you wanted to be shady and do an investigation, still enforce it while you're doing an investigation. Just like a TRO, you enforce it while you are doing an investigation. So as shady as the investigation may have been, You know what I mean? Wasn't one of the sheriffs, so I don't know. I'm honestly, I've only been paying attention to the federal cases and the Levy County cases, the Ohio case. I don't know. I don't know. Hey, screenshot this. All right. This reasoning fails to accept the appellant's well-pleaded factual allegations as true and fails to draw all reasonable inferences in appellant's favor. Appellants did not merely allege that Appellee Owen pondered the validity of the orders. Rather, they alleged Appellee Owen affirmatively refused to enforce the orders and advised law enforcement not to enforce them. Officer Williamson's report, which appellants incorporated into their complaint, states Appellee Owen would caution against enforcing this injunction. And that's that phrase again, would caution against is different than do not enforce. And that's that sliminess of lawyers and using and manipulating the English language. The officers, no offense to law enforcement, but some of y'all aren't the brightest crayons in the box. And some of y'all would interpret this as do not enforce. However, in a court of law, there's a difference between would caution against and do not enforce. And there's the problem. And that's my whole problem with this sleaziness of lawyers. Because you manipulate the English language to manipulate it so that one person interprets it one way and a court will interpret it in different, and you can go, well, I didn't say that, because technically speaking, you didn't. Yeah. And that appellant Risk was made aware of this and was told this report would be for documentation only. These allegations plausibly support the inference that Owen's actions effectively nullified the protection orders as a practical matter. When the assistant state attorney responsible for prosecuting violations of protective orders affirmatively refuses to enforce the orders and advises law enforcement not to enforce them, the orders lose their protective effect. Appellants alleged they requested enforcement at least 3 occasions beginning November 2023, and each time enforcement was refused based on Appellee Owen's position. And I really hope they put that in the other document. I'm curious to see what Owen's boss will say when the opinion put out by his boss in Tallahassee says the opposite of Dan's. Well, from what I understand is when we read through the motion to dismiss in this case, it was written by the Florida Attorney General. So, yes, the undersheriff and deputy testified in Ohio. Boy, was that a mistake. Judge was not happy nor impressed over her order not being recognized. Yeah. So the orders are entitled to full faith and credit. By deciding to investigate, Appellee Owen effectively relitigated the merits of the orders without providing appellants any notice or opportunity to be heard. Although the district court questions whether there's a private right of action under full faith and credit, or whether it's enforceable through civil rights statutes, procedural due process claims do not depend on establishing such a private right of action. 2265 provides that certain out-of-state protection orders shall be accorded full faith and credit. Appellee Owen was required to give full faith and credit to the protection orders and enforce them as if they had been issued in Florida. The district court questioned whether there is a private right of action under 2265 or whether it is enforceable through Section 1983. But procedural due process claim does not depend on establishing a private right under 2265. Full faith and credit mandate informs the procedural due process analysis by establishing the legal framework which in the Appellee Owen was required to operate. When federal law mandates that states give full faith and credit to valid out-of-state protection orders, and the state official refuses to comply, that refusal violates procedural due process. The federal statutory requirement of 2265 recognizes and reinforces the liberty interest in the enforcement of protection orders and establishes that state officials may not unilaterally disregard such orders without process. 2265 requires state to give full faith and credit to valid out-of-state protection orders, and although the district court questioned whether a private right of action under federal full faith and credit or whether it's enforceable through civil rights statute, procedural due process claims do not depend on establishing that. District court erred by conflating the statutory definition of law enforcement personnel under 2265. This was one issue that I had with the state of Florida, because there was a thing with the way the Florida statutes are worded where the state attorney is not an officer of the court, but not law enforcement. So what the hell is he? Like, I had a big issue with this when I first read the motion to dismiss and the statutes themselves, where Florida law or Florida state attorneys are not technically an officer of the court by definition, but they're not technically law enforcement either. They're like a loophole. And no, it wasn't. Oh, he was appointment of counsel from the state AG's office. Oh, sorry. The district court erred by conflating the law enforcement personnel for a procedural due process claim as appellate owned, though not law enforcement, acted under color of state law and exercised authority over protection order enforcement, making dismissal at the motion to dismiss stage improper. So appellants failed to state a claim because they have not alleged Owen was a court or law enforcement. This analysis conflates appellants' 2265 claim with their procedural due process claim. Even if appellee Owen was not law enforcement within the meaning of 2265, that does not preclude procedural due process claim under 1983. The relevant inquiry for procedural due process is whether appellee Owen, as a state official acting under color of state law, deprived appellants of protected interest without adequate process. Moreover, the district court's analysis resolved dispute, factual, and legal questions at the motion to dismiss stage. The complaint alleges that appellee Owen was a state official with authority over enforcement of protection orders in Levy County. Whether appellate Owen's specific role and authority brought him within the scope of 2265's enforcement mandate is a question that should be resolved after discovery, not on a motion to dismiss. That I agree with. That was another, if you go back and watch that stream, like my brain is like malfunctioning and buffering mid-stream because I could not get past this. And there was something in every document where I'm like, what the hell did I just read? And that was the one in the motion to dismiss, and I believe when we were reading through the statutes. It's one of those, like, if they're not an officer of the court and they're not law enforcement, what the hell are they? And yes, I agree, screenshot this. If he's neither, he shouldn't get qualified immunity. Yeah, and we all know how I feel about immunity. It's in the petty chat rules. It's in the petty chat rules. We don't like immunity around here. No one is above the law. All right. The district court faulted appellants for failing to allege what he was, in his view, supposed to do or how he should have enforced the orders. Criticism improperly demands a level of factual specificity that Federal Rule of Civil Procedure 882 does not require. All right, the plausible claim for relief, blah, 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 blah. By coordinating with law enforcement who told appellee Owen they need some help, or by other means, are matters that can be developed through discovery. At the pleading stage, appellants need only allege enough facts to show Owen had a duty to enforce the orders. District court's failure to draw reasonable inferences. Twombly, we've read through Twombly multiple times in multiple cases, in multiple people's motions to dismiss. Ashcroft v. Iqbal, I feel like we've regurgitated that same case law 1,000 times. Does anybody dream about Ashcroft v. Iqbal when they go to bed? And Linda Taz, just thanks for the $5 super chat. Just cause I appreciate that. I think those mistakes are intentional. Yeah. You know, I just, there's just a thing, Oh, I lost a subscriber during this stream. So thanks to whoever rage quit. Cheers. Appreciate you. We have a rage quitter. Where's Freckled when you need her? Dan Davis with the dad joke of the day. Cheers. All right. A claim has a facial plausibility when the plaintiff pleads factual content that allows the court to draw a reasonable inference that defendant is liable for the misconduct alleged. Appellants alleged they requested enforcement on multiple occasions and were told the report would be for documentation only, based on Appellee Owen's position. God, I hope that's in one of the emails. Shush. At least they didn't announce her departure. Yes, it's not an airport. However, speaking of airports, thank you, E. Poindexter. Thursday's stream, we will be going over the LaGuardia incident, and I am talking to a former colleague of mine who was on the ramp, as well as my mother who worked at the airport, and as well as Mr. Squid on the CRJ, because Lord knows we need more CRJ talk. However, I have diagrams. We will discuss it on Thursday. I saw her in experts chat like a week ago. Oh, and I talked to her on Discord a few weeks ago. She's busy. Yeah, rage quitting is the most shameful type of person. They do not live by the agree to disagree, and walk away with a hug makes them weak and lonely. Yeah, so for those of you who are here who don't know, before I went to school for occupational therapy and became an OTA, I was in the military and I worked in naval aviation as an aviation electronics tech. And I worked at a civilian airport for a civilian airline as a ramp agent while I started to go to college. My mother is a gate agent, and my spouse has a degree in aeronautical engineering and currently works in the aviation industry for 20 years. So in both military and civilian sides for multiple companies. So I have knowledge and sources. So I discuss things from not only my interest, my personal experience in avionics and ramp agent, my mother's experience as a gate agent, and I have pilots all over my Facebook page. So can I rage quit? No. No. They didn't announce their departure. So, yeah. Speaking of immunity, has anyone read the Supreme Court's Castle Rock case? No, I keep forgetting every time I'm done with the stream to write that down so I can look it up later. So, yeah. Yeah, just, have a good rest of your day. I love that. I have had an obsession with aviation since I was very little. Yeah, going back to like EAA AirVenture and Oshkosh. So, district court's contrary conclusion reflects an improper weighing of the evidence. I don't know. I didn't see it. Dan Davis, no. Well, for most people, it might be, but yeah. For me, I really don't care. Taken together, these allegations state a facially plausible claim for violation of procedural due process. And I like that they keep repeating procedural because there's two different kinds of due process. They identify specific actions Owen took, sending the email, requesting documents, refusing to enforce the orders. See, this one, I'm still hung up on that. And this is where I'm like, that's okay. I like you. Thursday. There's been some NTSB, and Chairwoman Hamidi is my spirit animal. I love her. She is one of the people I am fascinated by in all of the aviation cases I cover. There's been a couple of things going on. And also, I have some just basic information, and people have been asking me things, and I am in the process of fact-checking and actually making diagrams. So we can do a little what the NTSB won't do right now and do a little fact-checking. Plus, we're going to listen to the audio because the audio is important. And Vaza Aviation dropped the audio last night. So we're going to look at the audio or listen to the audio. So refusing to enforce the orders, advising law enforcement not to enforce them. Yeah. October 30th and November 20th, specific individuals involved, Williamson and Brett, whatever his fucking name is, don't care. I'm not calling him by the nickname because I just don't do that. However, I'm one of those people that I won't call someone by a nickname as to give them the benefit of the doubt, but if I mispronounce their name, I don't care. And specific harms suffered: physical harm, threats, emotional distress, fear of bodily or death of bodily injury, financial harm. Assistant state attorney performing investigative functions are law enforcement personnel. There it is right there. That's the question I had yesterday. I don't know anything, but I did stay at a Holiday Inn once, let's see. So far, Gail, we are good. So far, there's usually always one or two. But today, so far, we're good. We're at 100%. The functional approach to immunity emphasizes that an official's entitlement to absolute immunity. Here we go. What we've all been waiting for, what I've been waiting for. Emphasizes that an official's entitlement to absolute immunity depends on the specific function performed, such as advocacy in judicial proceedings, rather than their title. And investigative or administrative actions, even by prosecutors, are only protected by qualified immunity, not absolute. The determination of whether an official qualifies as law enforcement personnel and whether that official is entitled to immunity depends on the function performed, not the official's title or rank. The Supreme Court has applied a functional approach in determining whether an official is entitled to absolute immunity. This functional approach applies equally to determine who constitutes law enforcement personnel for the purpose of statutory enforcement obligations. The critical question is what function of the official was performing, not what the official's title or the title the official holds. State prosecutors are entitled to absolute immunity from damages under 1983 for all acts intimately associated with the judicial phase of the criminal process. And that's the thing. This never got loophole on Jeremy's favor, in my opinion, starting out. We'll see if it'll close or not. But intimately associated with the judicial phase of criminal process. They never got to the judicial phase. Therefore, you're not entitled to absolute immunity. Just saying. However, for acts done as an administrator or investigative officer, rather than the advocate, state prosecutors receive only qualified immunity. Prosecutorial immunity, however, does not apply when a prosecutor is not acting as an officer of the court, but is instead engaged in certain investigative or administrative tasks. Prosecutors are not absolutely immune from conducting investigative work before an arrest, making statements to the press, and providing legal advice to police regarding pre-indictment investigation techniques. And Janet, thanks for being a member for 8 months. Sorry I'm late. Promise to rewatch. You are late fee paid. All right. Complaint alleges Appellee Owen was investigating whether plaintiff Hales committed perjury. Appellee Owen himself concedes in his motion to dismiss. Be careful what you write. Be careful what you say. Be careful what you write. That he was investigating the Ohio court's jurisdiction over the restrained parties. This investigative activity is not entitled to absolute immunity. This means that Owen was functioning as an investigator, not as an advocate in judicial proceedings. Because at the end of the day, a prosecutor is an advocate for a victim. When a prosecutor's conduct pre-charging investigations, they perform law enforcement functions regardless of their official title. The email sent by Appellee Owen requesting documents to investigate potential perjury occurred before any charging decision and before any judicial proceedings related to enforcement of the protection orders. This shows that at this pre-charging investigative stage, Appellee Owen was not acting as an advocate for the state in any judicial proceeding. He was conducting a type of investigation that law enforcement officers routinely perform when deciding the existence of probable cause. I really hope this holds up. There's something with the last name Owen or Owens, because this dude, Laura Owens, Sarah Boone's lawyer for her trial, she went through a lot of lawyers, but the lawyer that actually went to court with her was James Owens. There's got to be something with the last name Owens that's weird. The fact that a prosecutor rather than a police officer conducted this investigation does not change its fundamental character as law enforcement function, and that a prosecutor may conduct such investigatory acts prior to the determination of probable cause. The appropriate inquiry here is not whether an assistant state attorney has the discretion to investigate an anonymous private individual for no reason other than the individual voices religious dissent and a local pastor complains at dissent. Rather, the question before this court is properly framed as whether an assistant state attorney has the discretion to participate in criminal investigations if done for a proper purpose, and whether in doing so he is authorized to issue an investigatory subpoena. Florida law makes that clear that a state attorney possesses such authority. Each state assistant attorney appointed by a state attorney shall have all of the powers and discharge all of the duties of the state attorney. The state attorney has the power to subpoena witnesses to appear before him and have them testify before him concerning matters which he is investigating. Let's hope this. I really hope that this can make it over that hurdle. Appellee Owen exercised decisive functional control over the enforcement of the Ohio protection orders. Complaint reasonably infers Owen's investigation and conclusions controlled whether Levy County Sheriff's Office would enforce the protection orders. When a deputy reported Appellee Risk's request for enforcement on November 20th, the deputy explicitly stated that he had reviewed Appellee Owen's email and that advised caution against enforcing the orders. There's that thing, advised caution against, is not the same technically and legally as do not enforce. It's like think about it from a medical perspective as a do not resuscitate. You have a DNR order. DNR is way different than a family member saying, I don't think they want to be resuscitated. No, there's a difference. Legally, there's a difference. Legally, there's a huge difference. And I think it should be heard in appellate court video chambers where arguments are heard live. Yeah, I'm thinking it. God, I would love that. I just haven't looked up anything in the 11th Circuit. Usually my appeals are limited to Florida. Florida State Criminal. So These allegations demonstrate that Appellate Owen exercised functional control over law enforcement response to the protection orders. His investigation and position prevented any enforcement action. The functional control over enforcement decisions places him squarely within the category of law enforcement personnel responsible for enforcement under federal law. This court should reverse the district court orders. The longstanding constitutional and statutory mandates, including the Full Faith Credit Clause and the Violence Against Women Act, clearly require officials to enforce the out-of-state protection orders, making it unequivocally unlawful for any official to refuse enforcement or investigate the protected person's motives, therefore defeating any claim to qualified immunity. Qualified immunity protects officials only when their conduct does not violate clearly established law. Here, the requirement to give full faith and credit is clearly established in both constitutional and statutory law. Full faith and credit clause has been part of the Constitution since ratification. Article 4's Section 1, the statutory implementation of full faith and credit has been federal law for decades. Specific requirement to enforce protection orders across state lines has been federal law since the enactment of the Violence Against Women Act in 1994. And yes, it says Violence Against Women Act. However, it covers everybody because not just women are, as we've demonstrated by The Bachelorette recently, Amber Heard, my ex's ex-wife, men are victims too. No reasonable official could believe that he had the authority to refuse to enforce facially valid out-of-state protection orders and instead investigate whether a protected person committed perjury in obtaining them. Yeah, I mean, it's reasonable to not like Jeremy. Not everybody in this world gets along with each other. However, there is a difference between not liking someone and not following the law and just that basic human decency. Which is one of the reasons, like, I don't call people by nicknames except for Lips because she personally insulted me. I'll call the Fleabag Thunder Cunt 1 because she went after my kid. I call Bruce names because he went after my kid. People who personally attack me, oh yeah, I will fucking go after you. However, people who show me a decent, like John Cook in the chat sometimes, will he and I ever get along and be friends? Probably not. However, I can show a basic level of human decency to someone that I don't necessarily get along with. As these officers should have done. You don't have to like Jeremy Hales. Not everybody is going to get along. You are small town folk and you don't like people from the north or, whatever. You do you, boo-boo. But at the same time, if you're going to have a fucking job, do it. Just, I was going to need a PO if I have to continue picking up his shit. Oh, there used to be a thing. The dude would leave for work on a Monday and come back on a Friday, and he took a week off. And like on a Monday, I started getting up and doing what I do. And he looked at me funny, and I said, "What? You don't think your shoes magically make it back to the closet on their own, right? You don't think the dishes you left in the living room magically march their way to the kitchen and get washed? No, I do that on Monday mornings." Florida Attorney General's 1996 opinion makes a compelling case that foreign protection orders issued under the Violence Against Women Act must be enforced by Florida law enforcement. And I read that a few months ago. That's true too. Not a Hales guy, but people forget George is also a protected party, and she seems to be a gem. That's true. She does really seem to be a gem. And also, last time I checked, when people are like, "Well, Hales isn't a woman," she's on this protection order as well, and she is a woman. I mean, last time I heard. Just saying. So when people talk about this protection order, like when you hear people that hate Jeremy say, "Well, Violence Against Women Act, blah, blah, blah." Well, George is on this too. So this isn't just a Jeremy thing, even though, well, one person hit the thumbs down. Ah, thanks, guys. The opinion states that a foreign protection order issued in accordance with federal law are enforceable by local law enforcement agencies in Florida without the need for registration or recording. The opinion emphasizes that law enforcement officers should enforce the protection orders as if they were an order of a court of Florida. Critically, the Florida Attorney General opinion states that the provisions of state law such that the Enforcement of Foreign Judgments Act are inapplicable to the enforcement of a foreign protection order. This directly contradicts Appellee Owen's argument that he was entitled to investigate the protection orders under Florida's foreign judgment enforcement procedures. The district court's conclusion that appellants failed to allege what Owen was supposed to do improperly resolves factual disputes of the scope enforcement obligations. The statute explicitly requires enforcement as if the order were issued in the enforcing state. Full faith and credit requires states to recognize and enforce final judgments, including protection orders from other states, without re-examining their merits. With respects to judgment, full faith and credit is exacting. Final judgment in one state, if rendered by the court with adjudicatory authority over the subject matter and persons governed by the judgment, qualifies for recognition throughout the land. A state may not disregard judgment of a sister state because it disagrees with the reasoning underlying the judgment. Yep, boomered. I am boomered. Hey Dion, how are you? The little decided that she wanted ice cream and she wanted to scream ice cream at me for a couple of minutes, and it's like we don't have ice cream. So I should be unmuted now. According to can y'all hear me now? So I didn't eat myself. I'm still here. You are in officer to officer mode on sound. I am here. Like, you're all done? I am not muted. Some people can hear me and some people can't. So I have to go clean up a situation with my toileting toddler. So I will be right back. thank you for your patience. Appreciate it. Dear to most, I'm muted. Yes, thank you for the $1.99 super chat. Dwayne, how are you? Haven't seen you in forever. How are you doing, sir? Thanks for the $5 super chat. Baby Squid Ice Cream Fund. Yeah, she's still saying, I want ice cream, I want ice cream. I gave her strawberry yogurt because that's the closest I got. So, muted and unmuted, dead air. What a stream. Race teachings. Aha, you're funny. You got jokes today. Thanks, Chris, for the £5. We can hear you. You'd always have ice cream. There might be a pint of Halo top strawberry buried in one of the deep freezers outside, but it's not something I can get too quick. So, yeah, this could be as bad as Banana Fund. We might activate Toilet Paper Fund. Oh, yes. The toilet paper bill is... Oh, and all I can say is for everything we've had to buy, thank God that certain things are covered by the health savings account. So, you know, and Tammy, thanks for the $5 super chat. Buy Baby Squid ice cream. Let's help Baby Squid get her ice cream. Yeah, she'll get a 1-2 when Daddy comes home. That's her word for a Swiss cake roll. Because that's Daddy's treat. That's one of the only sugar things he'll eat right now. And she said, I want 1-2. And Swiss cake roll became 1-2. So now she hears 1-2. If you hear me say 1-2, it's toddler speak for Swiss cake roll. The district court stated that appellants never alleged what he was, in their view, supposed to do or how he should have enforced the orders. This conclusion overlooks both the clear allegations in the complaint and the explicit requirements of the federal statute. Complaint alleges appellee Owen was required under federal law to give full faith and credit and enforce them if they were Florida orders. The U.S. Supreme Court specifies what appellant Owen must not do. Disregard the judgment of a sister state because it disagrees with the reasoning underlying the judgment or deems it to be wrong on the merits or inquire to the merits of the cause of action. What's the difference between a good lawyer and a great lawyer? A good lawyer knows the law. A great lawyer knows the judge. True. Owen investigated whether Hales committed perjury in obtaining them. The clear implication of these allegations is that the appellee Owen should have treated the facially valid orders as enforceable rather than investigating. Awesome. And Harry, thanks for the $5 super chat. Nutella Funds. And Ninja Puppy, thanks for being a member for 9 months. TP Fun to follow. Appreciate you. All right. Oh, goodness. We're almost done with this one. It only took us, 2 days. At the pleading stage, it's sufficient for plaintiffs to allege that refusal of officials to enforce valid protection orders possibly caused their harm, even if the direct harm was inflicted by third parties, therefore supporting reversal of the district court's dismissal. I agree with that. I think this was very, very well written. Ninja Puppy, thanks for the $4.99 toilet paper fund. Please invest in the 2-ply. And your picture right now is so stinking cute. Like, oh my goodness. Appellants do not claim that appellee Owen directly caused the restrained parties to engage in threatening behavior. Rather, appellants claim that appellee Owen refusal to enforce the protection deprived them of their legal protection. It seems like common sense, but it has to be written down. Yeah, I used to live in a town. I grew up in a town where everybody knows your business and everybody knows everybody. Hence why I'm not covering the Afroman trial, because everybody knows everybody. Ko-Fi isn't loading. Oh no. Oh no. Oh no. Awesome. I have no idea why. All right. The casual chain alleged in the complaint is straightforward. Appellants had a valid protection order designed to protect them from restrained parties. It makes sense. So this was signed by Randy. I don't think that Randy was the one who wrote this by himself. I think that this was there was somebody else involved in the writing of this, because that seemed to be written by someone who has appellate experience, and I don't know for sure if Randy does. He may very well. I don't know. I've never investigated. I've never investigated Randy and or Doreen to. You think Doreen wrote it? I've never investigated them because that takes. I generally don't go into lawyers' backgrounds who are not like actively in a law, like in a court of law. Like James Owens, I looked up his background and his bar, to see if he had any stuff. But I generally don't make it a practice to investigate lawyers because it's kind of a waste of time because most of them have nothing. Toilet paper, extra grab or extra comfort. Can we get a judgment on this? Extra grab, but always use a Cottonelle wipe or a stuff after the wet wipe after, because you never get a clean feeling like actually cleaning yourself. So, but I'm bougie like that. All right, guys. I'm going to see if there's anywhere I can send you. We will go over the next document, the other one, the 80-page one, on Friday, along with the bankruptcy stuff. So I don't have time today because I have to go to work tonight. But Friday around 3:00, 2:30 or 3, we should be doing it then, along with the bankruptcy stuff. And I'm going to see if there's any validity to the Lips bankruptcy and see if I can bring that to y'all too. So, oh no, none of that. I don't need an undercarriage flush. We just need a little, wet wipe here and there to make sure everything is fresh and clean. See who else is live right now and where we could go. Oh, somebody fixed their stuff. Thank you to whoever unhit the dislike button. That must be Snipe Hunter. Yeah, need a wet wipe foam. Those are expensive. I have some on my subscribe and save order, and I'm doing my subscribe and save order for the first of the month. They jump from for a pack, or like an 8-pack, from like $16 to like $24. It's like, holy crap. Like, jeez. Yeah, I don't get dude wipes, but it's something close. Budget on Amazon. I have they're called good wipes or something like that. Cottonelle wipes fall apart too easily and leave a red, they lint. It's weird. Great stream today, Squid. Thanks for the chat. Thanks, Lucia, for your constant great input on this case. Yes, he is the Florida law enforcement and qualified immunity expert, considering he had it for a while. Kofi worked this time. Let's see. Why am I still in sleep mode? The little put me in sleep mode, so I haven't been getting any notifications. And Jeff, thank you for the $50 Kofi. You are freaking amazing, and I don't know where this channel would be if it wasn't for all of you who support me, because it's just little old me, myself, and I doing what I can on my own. However, let's go to, a new week brings new focus. Go to Captain Kern. If you don't know who Captain Kern is, he is a mod on this channel. He is a friend of this channel. Go tell him that I said hi. He is doing some builds in his 3D printer. We should see what he's doing. But anyway, I got to get going. I got to get to feed the little, make sure dinner's ready for Mr. Squid when he gets home, and got to go. So today, spray and pray. It's not exactly what I think about when I hear the word spray and pray, but we'll go. But share this stream out. Let everybody know. And please help me grow this channel, because we've been shrinking ever since I said I was going to stop talking so much about this. It doesn't say I'm not going to talk about it at all. I'm just not doing every stream on this topic. So y'all have a great rest of your day. Tell Captain Karen I said hi, and bye, guys.